I'm back. Well, this is the two documents that were filed on April 14th, which would have been yesterday. This one is just the one that was filed on the 13th. It's the affidavit submitted by Griesbach, except for this time it's signed. The other words weren't. And now there's a 28-page document. United States District Attorney, District Court for Eastern. Sorry. This goddamn cold. Alright. Defendant Netflix Incorporated, advised attorneys hereby moves the court for order holding an ambience briefing on plaintiff Andrew Colborn's motion to lien him to bar admission of opinions and statements of plaintiff counsels at trial until such time as trial date has been set. In support of motion, Netflix states as follows. On April 6, 2022, plaintiff filed a motion to lien to bar admission of opinions and statements of plaintiff's counsel at trial. The motion seeks an order excluding from admission at trial in this matter any statements or testimony by counsel Michael Griesbach that constitute either personal opinions or hearsay. The motion is premature because no trial date has been set and summary judgment briefing is months away. Federal judges in Wisconsin frequently deny motions and lien them premature while discovery is going. Western District observed a similar situation. This case has not yet reached the summary judgment stage, so it is too early to know what issues, if any, will remain for trial. Until the case has progressed further, the court cannot determine what evidence may or may not be relevant at trial. Thomas A. Reese, case law. At this juncture, neither defendants nor the court can gauge what hypothetical evidence from Mr. Griesbach should be admitted at trial. If there is one, because the information context will evaluate the admissibility and challenge evidence, indeed, of the judges in district who post their preferred practices online. All instruct that motions and liens should be submitted approximately 2 weeks to 10 days before the final pretrial conference. There is no pretrial conference date even scheduled in this matter. The final pretrial will be scheduled after all dispositive motions have been resolved or, in event such motions are not filed, after the deadline has passed. Plaintiff's motion also premature because, as he acknowledges, Netflix subpoena to Mr. Griesbach is the subject of pending motion to compel. Plaintiff has not brought his own motion to quash the subpoena, opposed Netflix's motion to compel, or sought any sort of protective order. In fact, his counsel conceded in a phone call with counsel for Netflix that she agrees certain information sought by the subpoena is relevant. Nonetheless, in a meet and confer, his counsel explained that plaintiff filed his motion in limine at this early stages because he fears Mr. Griesbach has a large number of responsive documents and hopes to avoid the burden of reviewing them. Then, in an email, counsel for plaintiff tried to further justify the motion's timing by saying, "We need to have some clarity early in the proceedings as the extent of which the court will allow one of the plaintiff's legal team to be characterized as a witness." These arguments make no sense. First, if the court grants plaintiff's motion to lien, the decision is not determined of the pending motion to compel or plaintiff's need to review whether Griesbach produces evidence need not be admissible to be the proper subject of discovery. I need to talk to Travis. It's been a while. For the purpose of discovery, relevancy is construed broadly to encompass any matter that bears on or that could responsibly lead to other matters that could bear on any issue is or may be in the case. Second, no defendant has noticed Mr. Griesbach's deposition or suggested he would be called as a witness as the trial. Regardless, plaintiff's motion is hardly tailored to keep Mr. Griesbach off the witness stand. It goes much further, asking the court to preclude defendants' use of prior statements by Mr. Griesbach, whether he is called to testify or not. Finally, plaintiff improperly uses his motion in limine to attack Netflix and questions his counsel's ethics, asserting without basis that the Rule 45 subpoena to Mr. Griesbach was intended solely to embarrass or harass plaintiff to interfere with his choice of counsel. To the contrary, and is explained in detail in Netflix's motion to compel, Mr. Griesbach was so personally involved in the underlying events that a portion of his interview is included in Making a Murderer, and he relied on his personal experience, including the initial search warrant for the Avery salvage yard, which he drafted, in writing 3 books on the Avery case years before he became plaintiff's counsel in the matter. Netflix subpoenaed Mr. Griesbach not to embarrass him or the plaintiff, but because Mr. Griesbach possesses relevant information, and until Netflix's motion to compel is resolved and it is able to review Mr. Griesbach's documents and cannot meaningfully respond to plaintiff's motion in limine, nor can the court meaningfully rule in relevancy of the admissibility of those documents. For all the reasons, plaintiff's motion in limine should be held abeyance until such time as a trial date has been set in this matter. The court should not then issue a pretrial schedule to rest all motions in limine in an ordinary course of scheduling a pretrial conference date, an order briefing due 10 to 14 days in advance of the conference. Counsel for co-defendants Laura Riccardi, Maura Demos, and Crow Media, LLC, has informed undersigned counsel that they do not oppose the motion. Counsel for plaintiff has stated plaintiff opposes the motion. In the United States District Court, Eastern District of Wisconsin, Milwaukee Division, declaration of Lita Walker, Mary Lita Walker, under penalty of perjury. I am partner of Ballard Spare LLP in Minneapolis, Minnesota, and lead counsel for defendant Netflix Incorporated, and above referenced matter. I have personally knowledge of the matter set forth herein. I make the declaration in support of civil expedited non-episode motion hold in advance of briefing on plaintiff's motion in limine to bar admission of opinions and statements to plaintiff's counsel at trial. In a letter to counsel plaintiff dated February 15, 2022, I provided a non-exhaustive list of reasons why the information sought in Netflix subpoena to Mr. Griesbach is relevant or otherwise discoverable sometime after I sent that letter. April Barker, one of the attorneys of the record for plaintiff, indicated during a phone call that she agreed that at least some of the information sought by subpoena was properly subject to discovery. Specifically, she agreed that information that Mr. Griesbach gathered on how people in Manitowoc County responded to the verdict of Stephen Avery for the murder of Teresa Halbach and how they later responded to Make Your Murderer was discoverable because it relates to Mr. Colborn's allegation that Making a Murderer harmed his reputation. Plaintiff never moved to quash the subpoena. He's not opposed Netflix's motion to compel and has not sought a protective order. Instead, he filed the pending motion in limine during a meet and confer that occurred over the course of 2 days during the first week of April 2022. Ms. Barker explained that plaintiff filed the motion even though discovery remains were open and no trial date had been set, because he and his counsel fear that Mr. Griesbach has a large number of responsive documents and hope to avoid burden of reviewing them. Later, following further inquiry into whether the plaintiff would agree to postpone briefing on his motion, counsel for plaintiff confirmed that he would not agree, and by way of explanation stated, we need to have some clarity early in the proceedings as to the extent of which the court will allow one of the plaintiff's legal team to characterize as a witness. No defendant has noticed Mr. Griesbach's deposition, nor has any defendant indicated the intention to call him as a witness at trial. I declare penalty of perjury that the foregoing is true and correct. Proposed order. On consideration of defendant Netflix expedited non-dispositive motion to hold abeyance of briefing on plaintiff's motion in limine barred admission of the opinions and statements of plaintiff, counsel at trial, and in opposition thereto, and good cause having been shown, it is hereby ordered that Netflix's motion is granted. The court shall set briefing schedule on plaintiff's motion in limine to bar admission of opinions and statements of plaintiff's counsel at trial, such time, trial date, pretrial conference have been set, so ordered. Now, this is not signed. Just like we read the previous document was Griesbach's affidavit submitted to the courts, but not signed. So we might get more documents today. If not, it's going to be next week. Clear Dickman Hamilton, United States Court, October 23, 2017, decided October 23, 2017, filed. Reporter Kurt Art Klessing, Mark A. Heitzman, plaintiff, Anthony Hamilton. Counsel Kurt Mary Heitzman, plaintiff for Anthony Hamilton, blah, 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 blah. What was happening right here in Wauwatosa, Wisconsin. That's a little city here in, or village, I should say, in Milwaukee County. Judgment in a denying defendant's motion to strike, plaintiff's motion to strike the affidavits of Christopher Worth submitted, blah, 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 blah. In the past month, the works of the case have gotten a bit gumped up. The court hopes the order might sort things out forward. September 28, 2017, plaintiff filed a motion under civil asking the court to prohibit defendants from using the purpose of several pieces of evidence. The motion was captioned as a motion under civil, expedited non-dispositive motion, and the caption is a bit confusing, at least to the court. I don't want to read all this. This is just what happened in the case that they're citing, trying to... Oh, Mrs. Pepper was on that case. How convenient. Pamela Pepper had this case first, and then she passed it off to Ludwig, and then Ludwig gave it off to Judge Duffin, because he had, actually, Colborn's side requested Duffin to do the mediation between Netflix and Colborn's attorneys, because he had prior handlings of Brendan's case, and he knows about the case. But they didn't to come to no agreement, and it got sent back to Ludwig. And if they don't come to an agreement again, it's going to be sent back to another judge to confer and try to get them to get to a settlement. But I don't think they're going to settle. This is just case law for the case that they're citing. Another case. I'm going to put the documents in the description or comment section of the video, the link to it, so you guys can look over this all you want. No, that's a case from 2013. Another case. No. Yep, and that's the last one. So, I don't know. Not many of you in here, so y'all got any questions? I'm shocked that Colborn is asking $1 million for every episode. Now, I'm curious, is that every episode of the documentary, or just the episodes that he's citing that they defamed his reputation? But Paul Ward, you didn't have to do that, but I appreciate it. Thank you. Next time, just click the link on my YouTube channel page and just go to PayPal. but it's not necessary. But I thank you. Yeah, if he's asking for $1 million for every single episode, does that mean he wants $20 million? And him claiming that he lost $400,000 worth of income due to the documentary coming out? I don't know. Sounds like bullshit to me. Here's a footnote at the bottom of this, though. You guys can't see it on here. Let's see. Let me unlock that and scroll this up. It says, unfortunately, much of the party's briefing devolves into mudslinging and arguments of the merits of the case. The court has duly ignored the relevant material. The court expects that the parties will not include such wasteful arguments in any future filings in this branch of the court. The court will also be granting plaintiff's motion to seal their interim settlement report. So, yeah, these are all cases that were won successfully. That's why they're citing them. I'm anticipating documents be filed either today or sometime next week, and hopefully KZ files her motion sometime soon, because Stephen Avery spent enough time in prison. The state of Wisconsin is horrible what they did to that man. And it goes all the way from the AG all the way down. Peg Launensauter, Deb Strauss, Amy Lehman. Those are the three responsible for dragging on. Stephen Avery didn't get no money for being locked up. Besides that guy that set up the donations for him. And he really didn't get anything, because all the money he got, his attorneys for a civil suit, they got what? A lot of it. And then he used the remainder of it to get Dean Strang. And then Jerry Buting jumped on board. And Stephen Avery could have asked for a mistrial, but his money was gone. He wouldn't have been able to keep Jerry Buting and Dean Strang as his counsel anymore because he couldn't pay him. So therefore, he would go back to having a public pretender. And that's why the court systems are rigged for the rich people to prosper and poor people to lose. But, yeah. See you guys next time. Y'all stay blessed. Hopefully next time I come on, there'll be some good news in Stephen Avery's case. Besides the filing, I know that's coming, but what the courts are going to do about it is the big question. Before I go, Stephen Avery drafted that document asking the judge to recuse herself. But if you guys have been following this case, Kathleen Zellner, in one of her briefings, asked for Judge Sigwitz to recuse herself too when she submitted it to the Court of Appeals. But then they kept throwing everything back to the circuit court so she include everything. But procedurally barred. It's unfortunate. It makes no sense. I mean, Stephen has more than one violation, and it should take only one for him to get a new trial. But y'all have a great day. Stay blessed.